morning. But she's muted.
Okay. Good afternoon, my lord.
Good afternoon. How are you?
I'm fine, sir.
Well done.
Thank you, my lord.
Thank you. Yeah, so let's start back.
Yes, my lord. My lord.
Parties absent.
Yes, my lord.
Okay.
Yes, my lord.
Yes, appearance. CO.
Yes, my lord.
CO.
Okay.
For the claimant.
Yes, my lord. CO Oko, my lord, for the claimant.
Yes, Mr. A.O. Omenka. Is that so?
Yes, my lord. Acting DCL.
Yes, A.O.
Omenka.
Omenka.
Acting DCL for the defendant.
This is. You see, Benue State.
Benue State, my lord.
Benue State emoji.
Yes, my lord.
Makodi.
Oh. Hey,
Okay,
Benue State, Makodi. Minister of Justice, sir.
Okay, Benue State emoji.
Yes, my lord.
For the defendant.
Yes, my lord.
So the matter is ordinarily for judgment, ba?
Yes, my lord.
Yes, my lord.
File the motion, sir. We wish to bring it before your lordship, sir.
The matter is
Lord.
Ordinarily for judgment, but we have filed a motion. Yes. It's the one filed on the 13th of June.
It was filed on
13th.
It was
1-3.
It was filed on 13th of June, sir.
Yes.
My lord, yes. It should have been filed. It was to be filed on the 5th of June, but we had some forth and back from the registry, from the process registry.
That's it's okay. I'm just concerned about the date of the filing, not the. Yes.
Yes,
and it was served.
Yes, my lord.
And we are ready for.
Yes, my lord, subject to the convenience of the honorable court.
Mr. Omenka.
My lord, I am not ready to take this motion. It was served on me yesterday.
Yes.
Served for me yesterday at about 4 o'clock. So I am not ready. The judgment is arresting the motion is arresting the judgment.
Mm-hmm.
So if it's ready, the motion is already yet ripe for hearing, my lord.
Okay, so what do you do?
I would be asking for adjournment to respond.
Eh?
My lord?
Yes, I can hear you, Mr. Omenka.
My lord, if the motion, if you want to, I don't believe that there is need for this motion. But if you want to go ahead with it, the motion is not right for hearing today, my lord. I was served yesterday.
It's a motion to substitute the the documents, photocopies of the documents already tendered with the original copies.
My Lord, there's no need for that. It's already admitted.
Yes, yes.
There's no difference.
So is Mrs. Oko. Did you hear him?
Yes, my lord. As it is, the counsel to the defendants ordinarily have the right of response. However, my lord, the nature of the motion is such that the defendants do not have to take any action. We would rely on the records of the Honorable Court in the determination of the motion. And if the court's record is has confirmed that there are documents before the court which have already been admitted in evidence and have formed part of the judgment that my lord is about to deliver, then there will be no action that would need to be taken by the defendants. And moreover, my lord, the defendant has stated that it's not necessary since the court has already admitted the documents in evidence, that the motion is not necessary. That would mean that the defendants have gone through the motion and they have seen that it's not harmless. I mean, it has no prejudice against the defendants. And so, my lord, because of the nature of the motion, my lord, I urge my lord to take the motion, sir. Let us be guided by the records of the court.
Without the input of the, the defense counsel, without hearing from them whether they want to object or file any objection to the.
My lord, the judgment, even though we apply to stay the judgment pending the determination of the motion, we would be the judgment would be meeting the deadline, the 90 days deadline by tomorrow, sir. And the failure to file this motion as at when due is from the registry, sir. They were.
No, I'm not talking about. I'm talking about the since you have filed a motion now.
Yes, sir. Yes, sir.
To arrest the judgment.
Yes, sir.
That time limit will not apply now.
As the court pleases.
Yes. Since there is a pending motion, that time limit will not apply now because the court has to, dispose of the motion before delivering its judgments.
As the court pleases.
Even if the motion is filed on the date of the judgment, it still has to be looked at by the court and decide, either way.
As the court pleases.
And once a motion is filed, the issue of the time limit does not arise again.
As the court pleases.
Yes. So what do you have to say about it?
My lord, if it would not affect the time limit for delivery of the judgment, then we'll leave it to the determination of the court. If the counsel to the defendants can oblige a stand down, he can see if my lord can allow oral response so that he can respond orally and the court can look at his record and guide guide accordingly in respect of the documents that is sought to be substituted or cited, as the case may be. I wanted to come orally, but then I thought about being a court.
But okay, but Mr. Oko.
Yes, sir.
You tendered the, when you tendered the, let me see. I think when the documents were tendered, what the DDLD then said.
Yes, sir.
He said we object to the admissibility of some of the documents. The burial program of event of the claimant's daughter is not relevant. There are also some documents that are not certified are relevant. Then I did my ruling and admitted the documents.
Yes, sir.
Yeah, that is what happened.
Yes, sir.
Even though in the course of the submission of the legal counsel for the defendant, in the final written address, they have raised some objections about on the admissibility of some of the documents.
Yes, sir.
So, but at this stage of the proceedings, do you think an applicant can apply to substitute his documents that are photocopies with the original copies?
Yes, my lord. The rules of court provide for situations that are not ordinarily foreseeable in the rules, and that was the provision under which, pursuant to which the motion was brought.
What did the rules say?
My lord, the rule says that matters that are not provided in the rules should come by way of motion, that are not specifically provided by the rules should come by way of motion.
But this is an issue of evidence. When somebody is to tender his document, he will tender it through a witness, isn't it?
My lord, we tendered the documents through the witness.
Yes, the
were admitted after ruling was given after the objection of the defendant's counsel. Ordinarily, my lord, wouldn't have bothered the court and the defendant's counsel, but we just thought that the right thing should be done, and that's why we thought to bring it to the knowledge of the court. There will be no need to retender documents that have already been tendered and admitted, just that the originals, which were not nowhere to be found as at the time of trial, just to buttress the justice that the court had done in admitting the photocopies in the first place in accordance with the law establishing the courts. So, my lord, it will give credence to the ruling of the court admitting the photocopy, that the originals, that the documents already admitted as tendered are authentic, my lord.
Yes, Mr. Menka is.
My lord, the decision on this about admitting, the court has no more sponsors official. It can no longer go back to admit the other document that the court has already admitted. If they want us to go on with it, of this court, let us go and adopt it. This motion is necessary at this point in time.
Mr. DCR.
My lord, sir.
Can you hear me? Can you hear me?
I'm hearing my lord.
She's asking to substitute.
Yes, my lord.
I said she's asking to substitute.
Yes, my lord.
My lord,
erroneous because we are not retendering any documents.
I'm hearing my lord. This will not be necessary. The court has already taken a position in this matter, my lord. The court has taken a position of this matter. We have not gone on appeal in respect of this matter. There will be no need for this court to take this motion today. The second lapse of this motion is asking that the court should delete something from an evidence before the court. And my lord, if she wants us to have the agreement, the judgment, let us have it. If it doesn't want, then let them give me a time, I'll respond. And the court will take a position. If he wants the judgment today delivered by the court, let him withdraw the council withdraw the motion.
I don't know whether after the close of the case of the parties, you know, a litigant can apply to replace the documents already admitted and evidence with the original copy. It's like when somebody doesn't tender the certified true copies of his documents, then after issues have been joined and the court makes its ruling, then at the final address stage, the claimant or defendant will apply to replace, those documents with the certified true copies of the documents that he has. I don't know whether that is proper.
My lord, yes, the law is always growing, sir, my lord. And my lord, there's an alternative relief for just citing. The court will cite the originals. Yes, we have seen the original. And the originals were not existing, were nowhere to be found at the time of trial. Just citing it is an alternative relief which we have sought. So my lord can look that these are things that makes the law to be
okay, just to cite them.
Yes, sir.
My lord, even the alternative release will not work, my lord. If the alternative release or the main release, if the judgment is ready, and if he's sitting on
and Mr. Oko.
My lord, Mr. Omenka is usurping the powers of the my lord.
No, Mr. Oko.
Yes, sir.
I know that in trials, commenced by pleadings.
Yes, sir.
Documents are admitted, via a witness, isn't it?
Yes, sir.
Yes, it's only certified true copies sometimes can be tendered from the bar.
Yes, sir.
So in this case, the photocopies have already been tendered and admitted.
Yes, sir.
The trial in this case is commenced by pleadings, not affidavit evidence. Not an originating summons or originating motion. If to originating summons, I think you could file further affidavits. You understand, to attach the documents. But in this case, the documents were attended through a witness. Isn't it?
Yes, my lord.
So can a council now apply to replace them by way of motion?
My lord, it's not retendering of, that is why it calls substitution, sir. It's not retendering of a document. It's already before the court. The court have already relied on them for its judgment.
Okay.
So
Okay. Who is now going to come and say this particular document is replacing this document. This particular document is replacing this document. Doesn't this amount to dumping? You're just dumping document on the court. So it's the court that's now going to go and say, okay, this document is replacing this one. This one is replacing this one. Wouldn't that amount to speculation?
no, sir. It is stated the claimant has already referred to the documents as marked by the court.
Yes, but you have not brought new ones. How can the court now say, okay, this exhibit A is be replaced by another document, exhibit B is be replaced by another? How can the court be able to do that?
No, sir, it's not another document, sir. This, for instance, my lord, exhibit CIY1, which was marked by the court with that same number, is the same exhibit CIY that has been attached to the motion, the original of the CIY, and the exhibit number in the motion, it is the exact number the court has assigned to it.
You are the one now marking them, isn't it? They're not marked by the court.
No, sir, it is the court that has
No. The court only marked the photocopies.
The photocopy.
Isn't it? The court only marked the photocopies. You are not bringing new documents.
Yes.
Okay. What if there is a difference between the one marked by the court and the one you are bringing?
They are not different.
I can't hear you. 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 Mrs. Oko is cracking. Miss Oko.
Yes, my lord.
We can now hear you.
Okay, my lord. My lord,
it's still cracking. It's still cracking. It's still cracking. It's still cracking. Mr. Omeka, can you hear her?
I'm not hearing her, my lord.
So we are not hearing you, Mr. Ko.
Uh-oh.
Maybe Mr. Amenka,
My lord.
maybe she's trying to rejoin again, isn't it?
Okay, my lord.
Maybe she's trying to rejoin us. So let's wait for her a while.
Yes, my lord.
My Lord, can you hear me?
Are you back? Miss Oko, is she okay? Miss Amenka, she's not back, but Miss Amenka,
My lord.
she's not back.
Not yet, sir. My lord.
Maybe if you can, call her on phone.
Okay. Oh.
Hear me? Mr. Omeka, can you hear me?
Okay.
Can you hear me?
I'm hearing you now.
Yes, Mr. Oko. We can see you, but we can't hear you. We can see you, but we can't hear you.
I hear you.
Hmm? Yes, Mr. Oko. We can't hear you. Mr. Omeka.
My lord.
What's your view on the motion? Your reaction, I mean.
My view on the motion is that this motion is not necessary. It's uncalled for because a document already admitted is already exhibited before the judgment. Why are we replacing them? Who is complaining? So what's the necessity of this? We have not appealed against this. So it is for me, it is not necessary.
But
if they want to,
but Mr. Omenka,
my lord,
in your final submission, you complained about the some of the documents not being certified true copies of the original. Lord. I said in your final submission, yes.
Yes, my lord.
I said in your final submission.
Yes, my lord.
You have made a complaint that some of
Yes,
the
my lord.
documents are not certified through copies of the original, copies.
Yes, my lord.
Yeah, so it means that there is a complaint from the side of the defense.
Yes, my lord.
Yes. So maybe that's why she's trying to bring the original copies to the fore so that the court will be able to.
My lord, I perfectly understand.
Yes.
And the God has already ruled.
No.
We are the one that's supposed to. Yes, my lord.
Okay, yes, I can hear you, yes.
The court has ruled.
Yes.
We are the one to complain.
Yes.
On the visibility of the document, which already been admitted. So then there's no necessity to bring it. So there are two things he brought even here. There's one that said the statement to note is what the statement to note is what did it? My lord, I'm coming, my lord.
Okay.
I'm sorry. My lord. My lord.
I can hear you.
Oh, hey. There are two ways. Original to original, talking of amendment. Amended statement of oath. What is before the court is amended. What the court to delete the amendment, amended. So these are the things that we need to respond if he wants, or if he doesn't want the case to be hard to judgment to be delivered today. I don't
just forget about that one. Concentrate on the issue of the documents, replacement of the documents, the issue of the amended order or amended something. Just forget about that one.
My lord, even as it is now, this document cannot come in. This original cannot come in now, my lord.
Yes.
Through the council or through the council. Is the council in this matter?
Yes.
It's not possible, my lord.
Yes.
So whatever is before the court, if it's ready, let the court deliver the judgment, and we'll be bound by the judgment of the court. So this one, that is why I don't think there is any necessity of substituting the original with the photocopy because it is already admitted. The photocopy has been admitted by the Honorable Court.
Yes.
So that is the way I look at it.
Yes.
If the judgment is ready, let him withdraw this application and let the court deliver a judgment.
Okay. Yes,
let her withdraw the application.
Yes, Mr. Oko.
For over an hour now.
Yes, Mr. Oko. Mr. Oko. Mr. Oko. Mrs. Soko, she cannot even hear us.
He's not hearing us, my lord.
Yes, Mr. Menka.
Hello.
Yes, I think we can't be waiting for her indefinitely, isn't it?
Yes, my lord.
Since there's a pending motion that she has filed, and I have it via Zoom on Thursday.
Yes, my lord.
Can we just adjourn it to Thursday for the either judgment or
next week?
No, this week. By
Thursday, this week.
By 2 p.m. I have a judgment by 2 p.m. to deliver.
Thursday is 14. Thursday is 14.
No, Thursday will be, today is 15. No? Thursday will be 19th.
Okay, today.
Today is
so I'm before, okay.
Today is 17th.
It's 17th. Yes, my lord. Thursday, 19th, my lord.
19th, by 2 p.m.
I think I will put both for
Eh?
The 2 p.m. okay, my lord.
But yes,
2 p.m. will be okay, my lord.
Okay. Let's just adjourn, so that we either adjourn for motion / judgment. If she withdraws the motion, then I'll just deliver the judgment. Isn't it?
Yes, my lord. Yes.
So this is my ruling.
Yes, my lord.
The court and the defense counsel have waited for more than an hour for the claimant's counsel to rejoin the Zoom proceedings. But I believe due to network problems, she could not link up. Given the circumstance, the matter is adjourned to 19th of June 2025 at 2 p.m. for motion and or judgment. Meanwhile, here
As called,
notification
please.
issued and served on the claimant's counsel.
As called, please.
Yes. So, Mr. Meka, thank you so much for your patience.
Thank you, my lord. Thank you, my lord.
For keeping the court company. Thank you so much.
Yes, my lord.
I will send the link immediately after these proceedings to Suma, so I should forward it to you.
As called, please.
Thank you so much. Thank you.
Thank you, my lord. Yes,
Bye
my
for
lord.
now. Okay.
Yes, my lord.
Thank you.